make a start. So good morning, everybody, and thank you for joining us this morning. It's a lovely, beautiful, sunny day here. Although many of us may be feeling slightly disappointed after last night's events, hopefully the sun has brought a smile back to everybody's face. So today we are going to present our webinar, an essentials guide for principles on commercial agency law. And my name's Suzanne Carr. I'm a partner in the commercial litigation team at Myerson, and I'm joined today by my colleague Robert Brothers, who is a senior associate. We are both commercial agency specialists and look forward to sharing our knowledge with you today. So today's webinar will be recorded and circulated afterwards for those of you who want to revisit the information, or for those of you who aren't able to attend us live today, and it will also be posted on our YouTube channel. We will, as usual, have a question and answer session at the end, during which we'll try to answer as many questions as we possibly can. So if we could ask, please do post any questions you might have in the question and answer function, which you'll find at the bar on your screens. However, if there are any issues which relate specifically to your business, which you'd like to discuss on a one-to-one basis with us, and would prefer not to post those in the question and answer bar, then please feel free to contact either of us after the webinar, and we'll be more than happy to discuss those points with you at a convenient time. So moving on to today's agenda. Well, the purpose of today is to guide manufacturing businesses through the essentials of commercial agency law. So I'm going to start by providing a brief introduction to the commercial agents regulations and take a quick look at the current landscape. We'll move on to considering why it's important that principals are aware of the basics of commercial agency law, looking at how we identify a commercial agent, what are their rights, and then looking at an outline of the various challenges often encountered by principals. I'll then hand over to Robert, who's going to look at the key considerations for agency agreements and the potential entitlements for commercial agencies following termination of an agency. Our contact details will be shown at the end of the slides for those of you who'd like to get in touch with us on a one-to-one basis. So on to a brief introduction of the regulations. So if we just take a step back, in 1986, there was an EU directive which was passed in this area of law, which was designed to harmonise the various laws of the member states relating to agents. And at that time, the EU directive had to be implemented by each EU member state, and that was done by each country in its own way. So we do have a situation where each country has its own slightly different national laws. In English law, in 1993, the commercial agents regulations were introduced. And at that time, there was opposition to the regulations by the government at that time. And that was because the regulations didn't sit well with various aspects of English contract law. So the regulations have many mandatory features, and they limit the freedom of parties to contract on whatever terms they like, and that is that doesn't sit well with the English contract law system, which permits parties to contract on whatever terms they wish to do so. So this limitation introduced by the regulations was a concept which was very alien to English law. The regulations also introduce the concept of a duty of good faith. And that is a concept which you can see in other jurisdictions, but it's a concept which is, again, foreign to the English legal system. We then had Brexit, and Brexit didn't affect the impact of the regulations, and the regulations have remained in force since Brexit as retained EU law, and they continue to have the same effect today as they did when they were first introduced. There's recently been a proposal by the Conservative government to scrap all legislation which was derived from EU law, and so that included the commercial agents regulations. However, the government did decide to abandon that bill, and the regulations were removed from the list of statutes to be scrapped by the end of the year. However, in recent months, you may or may not be aware that the Conservative government began a consultation, and that was with a view to abolishing the regulations and potentially replacing them with a simplified framework. That consultation closed for responses last week, and hopefully many of you did have the opportunity to give your responses and views to that. So it remains now to be seen with the new Labour government what will happen with that consultation. It may be that the proposed reforms continue, but my view is that it's unlikely to be high on the government's agenda as it enters its first year of government. And I would suspect that if the government wishes to seek closer regulatory alignment with the EU, to mitigate the impact of Brexit, then the abolition of the regulations could well be completely off the cards. So that is something which we'll continue to monitor. The regulations are, without a doubt, an agent-friendly piece of legislation. So at first blush, their abandonment or deregulation may well be seen by principals as advantageous, although likely to be seen conversely as disadvantageous to agents. However, there may well be wider implications for principals which may be less obvious, and the abandonment of the regulations would certainly put principals in a different position, on a different footing to their EU counterparts. So moving on to look at whether you appoint a commercial agent. Many of you may have attended our previous webinars where we've looked at agency law, both from an agent's and a principal's perspective. But it is always surprising how many businesses still don't have an awareness of the commercial agents regulations, or indeed how the regulations may impact them. And that's particularly the case where businesses have long-standing agents and have never had to deal with poorly performing agents or termination events. So it's important that businesses are aware, if they do have commercial agents within their business, and understand their rights and the exposure the business might have if the agent is terminated. It's also important for principals to ensure that they don't inadvertently breach the regulations, because that could ultimately result in the agent being entitled to bring the agency to an end and the principal being liable to the agent for a significant termination payment. And Rob will look at that in more detail later. Now, it may seem that the identification of a commercial agent is very straightforward, but it isn't just a case of identifying if the business uses sales agents. And the reason that I say that is because not all sales agents are afforded the protection of the regulations. We have to consider the role of the agent and primarily identify whether or not they fall within the definition of a commercial agent in the regulations. And it's important to say that it's not determined by whether the agent has a written contract or not, that won't matter. The important thing is looking at the specific role of the agent in question. So just briefly, the regulations define a commercial agent as a self-employed intermediary who has continuing authority to negotiate the sale or purchase of goods on behalf of another person, the principal, or to negotiate and conclude the sale or purchase of goods on behalf of and in the name of that principal. So that's quite a long-winded definition. So we'll just have a look at what that does mean in practical terms for your business. So the phrase self-employed intermediary, that requires, as it suggests, the agent to be self-employed. So the really important point here is that the agent must be completely independent of the principal. And that independence is a feature which is very different to the control which an employer would have over its employees. Whether somebody is employed or self-employed is usually fairly obvious, but sometimes can be less clear. So some of the factors that would need to be considered are whether the agent is on the business's payroll, or conversely, are they responsible for paying their own tax? How is the agent paid? Are they paid a salary or are they paid commission on the sale of the goods? Are they responsible for their own time, provided that they just get the job done? And are they permitted to work for others? So all those questions need to be asked to determine whether or not the agent is strictly a self-employed agent or whether actually they are employed. A commercial agent must be able to approach customers and market the principal's goods to those customers. And importantly here, it must be goods. So the commercial agents exclude the sale of services. That's usually very straightforward. For example, medical devices, as an example, would be goods, whereas the sale of insurance products would be a service. But it does then bring us on to a slightly less clear area of the regulations. It still remains unclear whether certain products are defined as goods or services, and that usually arises where we have in intangible products, for example, software. The courts have intervened here and provided some clarity in this area. So, for example, gas and electricity can be classed as goods, whereas digital packages, for example, Sky TV, those are not goods. Software is another slightly confusing area. Software which is provided electronically is capable of being goods, but only where that software is provided under a perpetual license. For an agent to be a commercial agent and afforded the protection of the regulations, then the sale of the goods must be on the principal's behalf and not in the agent's own name. And then an important aspect is whether the agent has to actually sell the goods or can simply be introducing the principal's products. And the meaning negotiate, the general rule of thumb is that it's not necessary for the individual to actually have to sell the goods. An introducing agent is also captured by the regulations, and it's also not necessary for the agent to individually negotiate the terms or the prices of the products. So if the agent is selling from a fixed price list, that they will still be captured. A commercial agent is usually remunerated based on the goods they sell, and that's either by a commission as a percentage of the value of the goods sold, or by way of a retainer, or sometimes a mixture of both. I've recently had a query as to whether an agent who only has one principal can be a commercial agent, or do they have to be employed? That seems to be a misconception. There are many agents who do only have one principal. It's up to the principal themselves to choose how the agent is contracted. It's perfectly satisfactory and permitted for an agent to only have one principal. So we'll now move on to the rights of a commercial agent. This is an area where, again, I could talk for a long time. So I'm just going to run through some of the key rights commercial agents have. So they have a right to receive a minimum period of notice before the agency is terminated. They have the right to information and documents to enable them to perform the agency fully and properly. They have a right to a written contract upon request. So an agent who doesn't have a written contract is permitted to ask for one. They have the right to be paid commission on orders which are attributable to their efforts. They have a right to claim entitlements after termination of the agency agreement, and that's something that we'll look at later in the webinar. And they have the right to ask the principal for information about sales, where the agent is entitled to commission on those sales. The agent has the right to regular commission statements, and they have the right to expect the principal to act dutifully and in good faith at all times. If the principal acts poorly towards its commercial agent, it can be found to be in breach of the regulations. That can trigger a termination event if the breach is extremely serious, and that would give the agent the right to treat the agency as being at an end and claim various entitlements. So it is really important for principals to be aware of their obligations and of the agent's rights, so that they don't fall foul of that, causing a potential termination event, which could be extremely costly. Just looking a little bit more closely at the duty of good faith, it's, again, I've said earlier, it's one of the aspects of the regulations which doesn't sit well with the English contractual system. And it is a duty owed by principals which could quite easily and inadvertently be breached. There have been cases which have dealt with the duty of good faith, and it is seen to be analogous to the duty of good faith that's owed by an employer to its employees. So that requires the principal to act in a way that would not undermine trust and confidence. And one way that a duty of good faith could easily be breached is if the principal seeks to impose significantly different terms on an agent and the agent doesn't consent to those terms being imposed. So that all sounds fairly negative, I suppose, from a principal's point of view. But the good news is that principals do also have rights under the regulations, albeit they are more limited than the rights that the agents have. So, for example, a principal is also owed a duty by the agent of good faith, and agents are under a duty to cooperate with their principals. So where a principal seeks to impose minor changes on an agent, provided those changes are reasonable, then the agent would be under a duty to comply with the principal's reasonable instructions. So principals will sometimes encounter difficulties with commercial agencies. Now, agency is a great model for manufacturing businesses, and one which is used widely, especially where businesses might be in their infancy and seeking to build up a brand. But where principals do encounter challenges with agents, then it's really important that they know how to address those issues, to ensure that they can deal with the agent's conduct in a way which is not going to be in breach of the regulations. And hopefully that results in the problem being resolved. But if not, it protects the principal's position and hopefully avoids the principal being exposed to the agent for large sums of money. So we often see poorly performing agents as being a common scenario which can have effect on a principal's business. And that typically involves an agent either not hitting sales targets, not visiting all the areas within a territory that's been assigned to them. They may not be calling on certain customers in an area or on certain customers at all. They may just not be being readily available when customers try to contact them. And there's a whole other host of poor performance issues. And I think it's fair to say that it's probably one of the main reasons for principals looking to terminate an agent. The difficulty principals have here that an agent isn't an employee, and the agent has, by the very nature of them being an agent, a degree of autonomy from the principal when performing the agency. So whilst it may seem slightly odd, a principal who finds its agent isn't meeting mandatory sales targets, that is unlikely to amount to a serious breach of the regulations. That means the principal isn't entitled to terminate the agency with immediate effect, and that's the case even if the written contract might say otherwise. This is something which again is often not known by principals, but the agency contract may well say that the principal has a right to bring the contract to an end in certain circumstances. But that, whilst that might be the contractual position, that doing so may well be a breach of the regulations, and that's something that principals need to try and avoid at all costs. Another challenge that principals often meet is an agent who's refusing to comply with reasonable requests. For example, new software may have been introduced by the principal, and the principal wishes the agent to use that software to promote the products, or the principal may wish to introduce a different reporting format or a different frequency of reporting. Those are all generally reasonable requests which the principal can expect the agent to comply with. And if the agent is refusing to do so, then that may well be a breach of the agency contract, albeit probably not a serious breach which entitles the principal to terminate with immediate effect. Another common issue we see is agents who are selling competing products in breach of the agency agreement. That may well be a ground for immediate termination, but that will depend on what the agency agreement says and whether the agency prohibits competition. When it comes to competing products, it's really important that the principal records any agreements that have been reached with the agent, whether those agreements have been reached verbally or not. It is quite common for agents to say that they've been given permission to do various things, such as sell a competing brand. But if this hasn't been recorded in writing, it makes it far more difficult for the principal to prove that the agent is in breach and to discern what permissions the principal has given to the agent. So that's just a reminder, really, that it's really important for principals to ensure that anything which is agreed with an agent is recorded in writing. If an agent is deemed to be in breach of contract, then the principal must take care to make the right decision for the business. I've mentioned earlier that if the agent's breach is not serious enough to warrant immediate termination, then the principal must take care not to bring the agency to an end, as that could result in a significant termination payment being owed to the agent. Sometimes isolated breaches may on their own not be seen as serious, but breaches can have a cumulative effect. So if an agent continues to breach the contract, either in the same manner or in different ways, then eventually that can amount to a serious breach, which might give the principal the right to bring the agency to an end with immediate effect. So if you do experience concerns with an agent, do record what those concerns are, how the conduct is affecting the business. Do have discussions with the agents regarding those concerns, and ensure that the discussions which take place with the agents are recorded in writing. If any agreements are reached with the agent about how those concerns are going to be addressed, make sure that's made clear. make sure that the agent is very clear about what's expected of them going forward, and then ensure that follow-up meetings take place within a reasonable time scale, so that matters can be reviewed, and hopefully that will address any issues in the best possible way for the business. It's much more difficult to terminate an agency if the principal hasn't kept a written record of these matters. And if you do encounter serious issues with an agent, we would always recommend that a principal seeks legal advice at that stage before taking any steps to terminate. And that brings me to the end of my section. I'm going to hand over to Robert, who's going to talk some more about agents and their entitlements. Thank you.
Thanks, Suzanne. Morning, everyone. I'm just going to take us through the last points on our agenda, which are what are the key considerations for agency agreements and what are the potential entitlements for commercial agents on termination. So in terms of agency agreements, it's not a requirement for a commercial agent to have a written agency agreement. And we tend to see with older agencies that contracts are agreed verbally or by an exchange of emails, for example. If the contract's unwritten, the regulations essentially plug the gaps. And because the regulations are designed to protect agents, it's usually better for the principal to have a written agreement in place. And I'm just going to set out some of the advantages of a written agreement. So its terms can set out precisely what the principal expects from the agent in terms of performance, including sales targets, reporting requirements, quotas for customer visits, new account openings, general dealings with customers, the sale of competitive products, as Suzanne just touched upon. And these terms are generally binding and enforceable, provided that they're reasonable and realistic. The agreement can set out circumstances where a breach is serious or fundamental, which can give the principal the right to terminate the agreement in the event of an agent's serious breach. It can specify what entitlements the agent may have on termination of the agency agreement, such as the choice between an indemnity payment or compensation. And it can also specify what pipeline commission an agent will be entitled to receive after termination of the agency and over what period. And I'll speak a little bit more about that later on. It can include a principal's right to vary the terms of the agency, such as amending sales targets, adding additional product lines, or varying the agent's territory depending upon the needs of the business. And finally, if an agent signs up to that written agreement, it's very difficult for that to be challenged later. And non-compliance with the terms of the agency agreement could amount to a breach of contract. So all that being said, it should be noted that the terms of an agency agreement can't derogate from the regulations where certain rights that an agent has are mandatory. So, for example, the right to compensation or an indemnity on termination can't be contracted out of. And if the agency agreement contains a provision which excludes those entitlements, then that provision would be treated as void and unenforceable. And where a principal wants to vary an agency agreement, it normally can if the terms expressly provide for that. And minor variations are usually uncontroversial and can be implemented by providing the agent with reasonable notice. But I should say where variations are more substantial, such as changes to the agent's territory or commission rates. These need to be carefully considered and will usually require the agent's consent. And it's really important to note here that unilateral variations imposed on the agent without their agreement can have the potential to cause problems for principals, and that's for three main reasons. The variations might not be legally binding without the agent's express consent. It can undermine the relationship of trust and confidence between the agent and the principal, and that can amount to a breach of good faith. And depending upon how substantial the variation is and how it impacts the agent might treat the variation as a fundamental breach of the agency agreement and rely on that to terminate the agreement and seek damages and entitlements under the regulations. So the key takeaway from this section is that if you're seeking to vary the terms of an agency agreement, we should think carefully and consider how substantial the variation is and how that impacts the agent. And principals would be best to take legal advice if they're unsure. So finally, I'm going to run through the entitlements that an agent can claim on termination of their agency. And in practice, we find this the most contentious issue between principals and agents, since they'll often disagree on the level of entitlements and precisely what the agent's entitled to claim under the regulations. So as pointed out earlier, the regulations are unusual in the context of English contract law, since they automatically give the agent the right to claim termination payments if their contract is terminated by a principal. And these entitlements fall into four main categories, which I'm going to briefly summarize. So the first is pre-termination commission. So pursuant to Regulation 7 of the regulations, an agent is entitled to commission on orders concluded up to the date of termination of their agency, which includes orders that are invoiced by the principal but awaiting payment by the customer. That's usually uncontroversial, and the principal will just need to account to the agent for the transactions up to termination in the usual way. So secondly, we've got post-termination commission or pipeline commission, which I mentioned earlier. And pursuant to Regulation 8, the agent is entitled to receive commission on orders that conclude after termination of the agency for a reasonable period, and only if those orders are mainly attributable to the agent's efforts during the term of the agency. And the agent is also entitled to receive commission on orders placed which haven't yet been concluded. And that covers situations where orders have come in, but were not accepted until after termination. So pipeline commission is, it's fair to say, is less straightforward to agree with an agent, because at the point of termination, the principal mightn't know what orders will conclude in the next 6 to 12 months. There's no hard and fast rule when it comes to agreeing pipeline commission, and it very much depends on the type of product sold, the lead times, the complexity of the product, and how orders are concluded. And perhaps rather unhelpfully, the regulations don't define what a reasonable period is. But agents generally argue a period of 6 to 12 months is reasonable, and principals will argue that a shorter period applies. And basically, that means the appropriate reasonable period will be a matter for negotiation. So moving on to the next entitlement, we've got the minimum statutory notice period. So pursuant to Regulation 15, the agent's entitled to statutory notice of up to 3 months, depending upon how long their agency has lasted for. So if an agent has worked over 2 years they're entitled to receive the 3 months notice, and that's mandatory under the regulations. And if the agent isn't provided with the right period of notice, they can claim damages. So it's important to note that the agent and principal can't agree a shorter notice period that's set out in the regulations, although they've got the contractual freedom to agree longer notice periods if they wish. And lastly, the big ticket item, compensation or an indemnity. So pursuant to Regulation 17, the agent's entitled to receive a payment on termination of the agency agreement, and that is either compensation or indemnity. And compensation and indemnity are usually the most valuable elements of an agent's claim and require careful calculation. And the methods of calculating indemnity and compensation are also different. If there's a written agency agreement, the regulations allow parties to stipulate whether compensation or indemnity would apply. Therefore, if an agency agreement states an indemnity applies, the agent will only be entitled to claim an indemnity and doesn't have the option to claim compensation unless the terms of the agency agreement provide for that. But it's usually a binary choice, compensation or indemnity. And if there is no written agency agreement, or the agency agreement is silent as to the choice between indemnity and compensation, then the default is compensation. The consequences of choosing indemnity or compensation are quite significant, especially for principals. Typically, claims for compensation attract a higher payment to the agent, whereas the indemnity payment is capped at an average of the last 5 years' commission income. For that reason, indemnity is generally seen as more advantageous to principals and provides more certainty on termination. So in this very final section, I'm just going to comment on when a principal may be liable to pay indemnity and compensation and the exclusions. So an agent's right to claim these entitlements might depend on the circumstances of how the agency is terminated. So the right to indemnity and compensation is automatic on termination of the agency, but there are exceptions to that rule. And pursuant to Regulation 18, indemnity and compensation is not payable if the agent's been terminated by the principal because of the agent's serious breach of the agency. And we would normally term that as a repudiatory breach or a fundamental breach. We've got another scenario where the agent assigns their agency to another agent. So, for example, where the agent assigns it to a third party with the principal's consent, the outgoing agent is not normally entitled to claim an indemnity or compensation payment. The right to indemnity and compensation is also lost if the agent fails to notify the principal of their intention to claim the entitlement within 1 year of termination of the agency. So, for example, if an agent is terminated and they don't notify the principal at all, either verbally or in writing, that they intend to claim compensation or indemnity, then they lose their entitlement altogether. So that's just something to watch out for. The right to indemnity and compensation is lost if the agent simply terminates the agency himself for convenience. But just on that last point, there are still circumstances where an agency can terminate an agency agreement and preserve their entitlements. For instance, the agent can terminate their agency by reason of retirement due to ill health, or where they've reached a reasonable retirement age. And also, if an agent is forced to terminate an agency agreement because the principal is in serious breach of the agency, then the entitlements are preserved. So that brings us to the end of the webinar, and we hope that you find it useful. So that just leaves the questions and answers section. So if you want to just populate these, and we can go through them and answer as many as we can within the time allotted. But of course, if you want to message us directly, our details are on the last slide, so feel free to do that as well. So we're just going to take a couple of minutes to read through the questions. So if you could just bear with us.
Thanks, Rob. So there are a couple of questions already in the Q&A. So I'll just begin with the first one. So the question is, how would a principal stand with IR35 if an agent is solely working for that principal? So I must caveat this by saying that I'm not an employment lawyer, and nor am I qualified to give any tax advice. But I am aware of IR35, and I'm aware that it is a set of tax rules that essentially governs disguised employees. So people who are working in a contractor capacity, but are essentially employees, so that they ought to be taxed as employees. So the situation here is that somebody who is a disguised employee, effectively an employee and taxed likewise, that is completely at odds with the concept of an agent who has to be entirely independent and autonomous from the principal. So if somebody is deemed to be a commercial agent within the regulations, they cannot be subject to IR35, and conversely, somebody who is a disguised employee will not be a commercial agent. So hopefully that answers that question. And then the second question is regarding the rights of an agent at the point of their retirement. So, Rob, I'm just going to pass over to you because I know you've touched on this already during, but you can maybe just expand on it slightly.
No, thanks, Suzanne. Well, yeah, so I had mentioned that the agent loses their entitlements if they themselves terminate the agency agreement, but there are just some exceptions to that. And as you've rightly pointed out, as the questioners rightly pointed out, it's the entitlements are preserved if an agent reaches a reasonable retirement age. Again, retirement age isn't defined in the commercial agents regulations, but we tend to rely upon what limited authority there is out there on this issue, which where the courts have essentially said that a reasonable retirement age would be, for example, when the agent would be entitled to draw their state pension. But some of these cases are quite old, so I think the state pension age as at the date of that case was 65 years old. But I know that the pension age has since gone up. I would say that if an agent has reached 65, then they're within a good shouting distance of a reasonable retirement age, and probably they would, if they retired at that age, would be entitled to claim their entitlements in the usual way, and that would also include their entitlement to compensation and indemnity. So I hope that answers your question somewhat, but obviously if you wanted like some more specific advice on the point, I'm more than happy to take a direct question after the webinar. So
Thanks, Rob.
We've a few more there, Suzanne.
Yeah, there's a question from David, which is what agreement, if any, is given to an agent selling intangibles. I think this is a difficult question to answer without more information. It's going to very much depend on the nature of the intangible product. So if it's a question of whether that product is classed as goods, and we would need to understand more about the nature of the product and to consider the case law on the various points where it's been considered by the court. As I alluded to earlier, that there have been, developments in this area over recent years, and so we do now have some more clarity about which types of intangible products might be classed as goods, but there are still some types of intangible products which will not be classed as goods, and so agents selling those will not be afforded any protection from the regulations.
Yeah, so we still got a little bit of time, so we can go through there's some more questions coming in. So I've got a question. I have a long-standing agent, 25 years, who's retiring at the end of the year. Is he entitled to a retirement payment, and how do I calculate that? It's sort of similar to the question that I've already answered, really. But yeah, it's a good one. It'll all depend upon how old the agent is, and whether them reaching that age is a reasonable retirement age. You can also look at the circumstances of your own business as to whether other agents have retired at a similar age as to the agent who's proposing to retire, or whether, what's the sort of average retirement age in your business, and also, I suppose, the nature of the services that the agent carries out. If they're required to travel here, there, and everywhere, and it's more physically demanding, then that could form the basis of an argument that they have reached a reasonable retirement age. And in terms of the retirement payment itself, well, that would just involve if the agent is entitled to retire, then the retirement payment is just simply a calculation of the entitlements that I just ran through. So you've got your pre-termination commission, you've got your pipeline commission, so that's a commission after the agency has terminated. If there's any sort of notice requirements there, but generally an agent will just simply, if they're retiring, they'll just agree an exit date. So that should be relatively straightforward. And then finally, you've got your indemnity and or compensation. So we'd have to have a look at the agency agreement itself, if there is one, to see which entitlement applies, and then go through the calculation. So I hope that somewhat answers your question. But again, we can speak more after the webinar, if that would be helpful.
Thanks, Rob. And the next question is whether a principal seeking to introduce a written contract that has not been enforced previously to agents who've been under a verbal contract for many years, does the agent have to agree to sign this written contract, or will they be in breach? So I think the simple answer to this is that you, as a principal, you cannot force an agent who has been under a verbal contract to sign a written contract. The argument against that would be if the written contract was very simple and was an absolute reflection of the verbal terms of the agency, then there would be a potential argument that the agent it would be sort of under a duty of good faith to agree to that written contract, because it simply represented the terms of the agency under which they'd been working for many years. But I suspect that a written contract would introduce new terms to the agency. That would be the reason for the principal wanting to put the terms in writing. And so to the extent that those new terms are significantly different to the current verbal terms, then the agent would be entitled, if they wanted to say, no, I'm not prepared to sign that contract. Then there's another question from David, which is along similar lines, which is what happens in the event that an existing agent doesn't agree to sign a new contract. So similar answer really, in that the existing agent has the right to refuse to agree to sign a new contract if the terms of that new contract are substantially different. And so it's very much a case of considering each individual case on its own facts, looking at what the terms of the agent's existing agreement are, whether those are terms that have been agreed verbally or whether there's an existing contract, and comparing that to the proposed new terms in order to advise the principal whether they have a right to impose the new terms. Rob, if I can just hand over to you, I think there's
there's
a couple more questions.
There's a couple more here. So I've got one here where agents have had a variable retirement compensation indemnity previously, but the principal is seeking to change their offer from what has been offered, a lesser amount, essentially. Is there a minimum requirement or regulation on what compensation indemnity should be offered to the agents? So if I'm reading that correctly, it sounds as if you've had discussions with your agent, and you've offered a potential retirement package or an exit payment as part of that negotiation, but you've sort of since revised your position. You're perfectly entitled to do that. There is no minimum offer that a principal needs to make, nor is a principal compelled to make an offer either prior to or after termination of the agency agreement. But I should say that there's nothing wrong in principle with trying to negotiate a settlement figure. It's often the better strategy than defending a claim brought by the agent at a later date. So say if the agent terminated for retirement, and provided they're entitled to do that, then they would have the right to bring a claim. So they could likely instruct solicitors to bring that claim for you. And then I suppose you are getting into the realms of risk of court proceedings being brought against the business, which would be best avoided. So I suppose in answer to your question, no, there is no minimum requirement for a principal to make an offer or any level of offer, but it'll all depend upon the circumstances, and you might be best getting some advice on the actual level of entitlements that an agent might be entitled to claim, and then base your offer on that calculation.
Thanks, Rob. I think the final question relates back to the IR35 query that I dealt with earlier, and the query is from Tony, and it's about whether, if the agent uses tools belonging to the principal, such as if the agent has a company email address, maybe claims expenses from the company, uses company telephone, i.e. uses the principal's tools, does this make them an employee? There was a recent case exactly on this point, where there was a sales agent who had a desk at the company office, used company telephone, other company facilities, and in that particular case, the agent was deemed to be a commercial agent, albeit they did use some of the principal's tools, because ultimately they had independence from the principal. So the simple answer is the agent may be using some of the principal's tools. That doesn't prevent them from being a commercial agent, but the exact situation would have to be considered in order to decide whether or not the agent fell within the regulations, or whether there was a lack of independence, meaning that in effect that agent was essentially an employee. So that brings us to the end of today's webinar. I'm very grateful for everybody who's attended. We do hope you found it very useful. And as I say, there will be a recording circulated later. So if you want to dip back in relation to any aspect, then you've got that available to you. So thanks again for attending today, and I hope everybody has a great day. Thank you.
Thank you.